Welcome to the European Parliamentary Research Service podcasts.
Once an EU law is passed, it may be necessary to define the technical nitty-gritty, or to ensure it's implemented under uniform conditions across the EU. That's why the European Parliament and the Council can authorise the European Commission to adopt delegated and implementing acts. But what are they, and how to choose between the two? Stay with us.
Lawmaking by the executive is a phenomenon that exists not only in the European Union, but also in all member states, as well as in other jurisdictions.
Before the Lisbon Treaty, executive legal acts were adopted by the European Commission under the watchful eye of specialised committees composed of national experts. That system was known as comitology.
But in 2009, partly in response to the Parliament's call for greater oversight and democratic legitimacy of comitology acts, the Lisbon Treaty introduced delegated and implementing acts, and the distinction between the two. Now, what are we talking about?
In a nutshell, delegated acts let the Commission specify or add technical details to EU laws, while implementing acts ensure uniform conditions for their implementation across the EU. Now, they're not only qualitatively different, they're also adopted under different procedures with different types of involvement of the European Parliament, the Council, and the Member States.
They are both very common. In 2023, the Commission adopted over 300 delegated acts and over 900 implementing acts. Now let's start with the delegated acts. They are adopted by the Commission on the basis of a delegation of power granted in an EU law, also called the Basic Act. But this delegation of power is subject to strict limits.
Yes, it is. For example, a delegated act can only supplement or amend non-essential elements of the Basic Act, so not to touch on the core elements. The Basic Act must clearly define the objectives, content, scope and duration of the delegation of power.
Moreover, both Parliament and Council have the right to revoke that delegation of power or object to a delegated act, as long as there's an absolute majority of MEPs in favour and at least a qualified majority of council members. Although in practice, Parliament has never exercised its right to revoke a delegation of power.
Now, how are delegated acts adopted?
Well, the Commission adopts them after consulting with groups of experts from all EU countries, although their views are not legally binding. In some cases, citizens and other stakeholders can also give feedback on the draft text of a delegated act.
Once the Commission has adopted the delegated act, and provided neither Parliament nor Council have any objections, it enters into force. If one of them objects, usually within 2 months, the delegated act is repealed immediately. In practice, such veto is rare, but it does happen.
Now, what about implementing acts? Stay with us.
Implementation of EU law rests primarily with EU member states. However, in areas where uniform conditions for implementation are needed, from taxation, agriculture, the internal market, health through to food safety, the Commission or the Council, when it comes to foreign and security policy, can adopt an implementing act.
So how are these adopted?
Before the Commission can adopt an implementing act, it must consult an expert committee in which every EU country is represented. This allows member states to assist and oversee the Commission's work.
The Parliament's and Council's scrutiny powers are much weaker with regard to implementing acts, compared with delegated acts. They can neither object to an implementing act nor revoke the delegation of power. If they think a draft implementing act exceeds the implementing powers provided for in the Basic Act, the only thing they can do is ask the Commission for a review.
So, how to choose between delegated and implementing acts?
Well, truth is, the distinction made in the Lisbon Treaty between the two is clear only on the surface, and according to some academics, the very nature of the divide is problematic.
So, ultimately, the decision whether to regulate all details in the Basic Legislative Act, to delegate some non-essential aspects to the Commission, or to authorise the Commission to adopt implementing acts is often a political one, based on different institutional interests. Here's Irmgard Engelmeier from the European Parliamentary Research Service.
In principle, delegated acts focus on the what, while implementing acts should define the how. But it's true that in practice, this delineation is not always clear and can create tensions at times. Unsurprisingly, the Parliament tends to prefer delegated acts because this is where it enjoys greater scrutiny powers. Conversely, the Council has a preference for implementing acts as they strongly involve national experts.
In 2019, the Parliament, the Council and the Commission agreed on a number of detailed criteria for choosing between implementing or delegated acts for specific subject matters.
The European Court of Justice, while granting that the Commission enjoys discretion regarding the choice between implementing and delegated powers, has exercised judicial review of delegated and implementing acts on a number of occasions.
In some cases, the review was initiated by Parliament by lodging an action for annulment to the Court. For instance, in 2014, Parliament successfully challenged a delegated act on the Connecting Europe facility, arguing that the Commission had exceeded the power conferred on it by the Basic Act.
More recently, it again successfully challenged an implementing act to the REACH regulation on chemical substances.
To ensure transparency, the Commission keeps an interinstitutional register of delegated and implementing acts, which gives an overview of the different steps in their life cycle.
Want to know more? Check out the EPRS website or our app.
This is a European Parliamentary Research Service podcast.
Thanks for listening.